Welcome to Smith, Gambrell, and Russell's live webinar on the topic Health and Welfare Employee Benefit Plan Issues for 2018 and Beyond, Planning Ahead for Open Enrollment 2019. This is the first of 4 short presentations regarding healthcare and welfare plan issues. Today's webinar will be approximately 45 minutes. Please feel free to add your questions to the chat as the presentation unfolds. Should you have any technical issues, call Zoom support at 1-888-799-9666 extension 2 and reference webinar ID 555-397-743. After the webinar concludes, we will reach out to provide you with the PDF copy of the presentation. Laura Andrew will be presenting today's webinar. Ms. Andrew is a partner in the Executive Compensation, Employee Benefits, and Healthcare Practices of Smith, Gambrell, and Russell with a special emphasis on healthcare. Ms. Andrew advises clients in all major aspects of employee benefits. Her practice concentrates on topics such as welfare plans, healthcare reform regulation, and federal and state healthcare laws. Now I'd like to turn it over to Laura Andrew to begin the presentation.
Hello everyone, this is Laura Andrew, and today we're going to be talking about open enrollment topics. And just to let you know what the focus is going to be, we're going to talk first about just some open enrollment basics as a reminder for those of you who are very familiar with it. Just the importance of your open enrollment materials, the contents that I would recommend, and then we'll talk a little bit about ACA requirements because they have not gone away, and ways that you can maximize the value of your open enrollment. I'm also going to talk a little bit about the required disclosures and notices that should go with your health and welfare enrollment, and just then some other thoughts and considerations. So first, let's talk about what open or annual enrollment is. And just so you know, it doesn't always have to be calendar year. Different companies have different schedules. But many companies offer employees a chance to change their elections for certain benefits once a year. And generally, this applies only to health and welfare benefits such as medical, dental, and vision. And just so you know, when people talk about health coverage, that's what they're talking about is medical, dental, and vision. Also, life and accidental death and disability, or ADD, short-term and long-term disability, and then other voluntary benefits such as life insurance for dependents, cancer coverage, critical illness coverages, and now there's been new additional ones that people add like identity theft, pet insurance, legal services, and a variety of other types of voluntary coverages that may be offered to employees. So some companies have what is called a evergreen enrollment, where basically if employees are not making any changes, they don't really have to make an election. Now, the only exception to that is annual elections are required if someone is electing a health spending account, or FSA as it's typically known, or dependent care spending account. Now, health savings accounts don't require new elections every year unless the employee isn't eligible anymore because they're no longer in a high deductible health plan. Because as a reminder, you can't have or contribute to an HSA unless you are in a high deductible health plan. So just as a reminder, I'm sure most of you remember this, health and welfare plans are not considered to be vested. That is, a company can change or terminate them at any time. I will say that most companies make changes to their health and welfare plans in open enrollment, or generally if it's a calendar year plan, they make changes to be effective for the following January of each year. And communicating these changes during open enrollment is a good way to also meet the legal notification requirements under ERISA, ACA, the Affordable Care Act, and the Code. So just as a reminder is that open or annual enrollment, it doesn't apply to retirement benefits such as 401k plans, which have their own requirements in terms of when participants can make changes. So why is it important? Well, I'm sure you all know, benefits are generally the second largest expenditures that a company makes. And in a survey that Aflac did, 92% of employees don't change anything and they just sign up for the same benefits. So this shows that if you can make an impact, perhaps you can influence what employees choose. And as mentioned on the screen here, there have been other surveys done by other groups like Heiser Foundation, finding out that most employees don't understand health plans and their choices for health plans, including medical, dental, and vision. And you have to be careful. Inaccurate or unreadable materials can create employee dissatisfaction and legal issues. Of course, some of the unreadable information can be required under ERISA, where you have to use certain keywords. So to the extent you can, you need to use plain English. So when you're doing your written communications, you need to make sure that it's targeted to the workforce that you're speaking to. And you can use different communications for different groups. And if, for example, you have a large group of Spanish-speaking employees, you may want to consider having at least some kind of disclaimer saying that they can contact someone in HR if they can't understand the materials, or perhaps even if it's a large enough group, you may want to consider putting the open enrollment materials in that other language. And of course, if you do that, you have to be careful that it's accurate to avoid miscommunications. And one of the things that's also important is that the information that is in your open enrollment, it should line up with the information that's in your summary plan descriptions or your SPDs if you are subject to ERISA. And we'll get into that a little bit more in a couple of minutes. And also, open enrollment, or you can convey the value of the benefits. Sometimes employers will also include how much the employer is paying towards the cost, for example, of the premiums, and that's something that they can convey to those employees. And depending on how you do your open enrollment, the timing, you can also distribute the required legal notices and information about other benefits with your open enrollment materials, so you can reduce the cost by not having to do a separate communication. So what should be in your open enrollment? Well, of course, you have to tell them election instructions, how they have to elect. If it's evergreen and they don't have to actively make a change, well, you need to say that. And of course, you need to give a benefit description so they understand what they are electing, and then what the employee is going to contribute, what their contribution cost is, and what their out-of-pocket costs are. And that applies mostly for your medical coverage and your dental coverage. And then also you want to talk about the eligibility. So employees know, are their dependents eligible? If so, who's considered a dependent? And you could include a brief reference and then either link it or reference the official plan materials, so you don't want to have an inconsistency in eligibility between your open enrollment materials and your legal materials, like your summary plan description. And then, of course, you want to talk about the benefit election period, i.e. usually it's going to be annual. And then how long you give them to look at the materials and make the election, that's really up to you. That is not something that is mandated by ERISA or the code or any other applicable law. Of course, you want to make sure you give them a long enough time, but on the other hand, if you give them too long, they may forget about it and not make an election. So, that's just something to know, though, is that legally there isn't a specific period that you have to choose. So what else should put in there? Well, of course, you need to put essential details that they need to make a decision. For example, high deductible health plans, which, as you may remember, are plans that meet specific criteria in terms of first dollar expenses, what portion of the cost does an individual have to pay before there's any coverage. And if you're talking about that, if the company has a health savings account, or if individuals can set up the health savings accounts, you want to make sure you explain that concept and how it works, especially if the company is making a contribution towards that HSA. And then also, if you also have flexible spending accounts and dependent care spending accounts, you want to reference how the flexible spending account works with that. Because as you know, if someone that is in a HSA, it limits a little bit more what can be reimbursed from the flexible spending account if they have a high deductible health plan coupled with an HSA. You also want to talk about the tax implications for non-tax dependents. For example, domestic partners. If you provide domestic partner coverage, as you know, if they are not a tax dependent, there is going to be some imputed income for the employee, and you want to explain how that works so they understand it. And if employees have the ability to choose pre-tax and post-tax elections, you want to make sure they understand how that works and the consequences of both. So it's important that you communicate the options and special requirements. One of the things that we often see, for example, if an employee wants to add additional life insurance after their initial eligibility, they have to provide proof of insurability. And if that is required, you want to make sure you set that out, because there have been appeals by employees based on the fact that they say that they didn't know or didn't understand that there was proof of insurability required. So if you set it out in your open enrollment materials, then it's very clear and you have proof that you can provide. You can also use proof for other purposes. For example, one of the big issues for next year is that the individual mandate under the Affordable Care Act, that is the requirement that individuals have health coverage or pay a penalty, has been reduced to 0. So basically it doesn't apply for next year. So you might have more employees that say, I don't have to have coverage anymore, and I think this employer coverage is too expensive, so I'm just electing not to get it. Well, written proof of that election will be important, or could be important, if you are a company that is subject to the ACA reporting requirements. That is, if you are an employer that employs more than 50 full-time equivalents, you have reporting requirements, and although employees or individuals no longer have to have health coverage, employers still have to offer it. So you will want, and you have to offer it. The mandate for employers is based on employers offering it, not on employees getting the coverage. So that would be, that's important that you have proof of that election, especially for next year since it's the first year. So talking about the Affordable Care Act, if your plan is still grandfathered and there really are not too many of those left, then you need to verify if you've had any changes in open enrollment materials that are going to change your status. For example, as a reminder, a grandfathered plan, you had to have it in place December 23rd, 2010, which is just before the effective date of Affordable Care Act. And you have to have continually adhered to guidelines that have been in place, where basically you aren't allowed to make a lot of changes in cost and or coverage without losing your grandfather status. So if you are grandfathered, one of the other requirements is in your open enrollment materials, you might put your annual notice of grandfather status, because you have to provide that every year. So what else under the Affordable Care Act? Well, there's limits on cost sharing and out of pocket, OOP, as some people call it. And for next year, it's $7,900 for single coverage and $15,800 for family. And then the HSA contribution limits, you also have to mention those. And that's $3,500 for single coverage or $7,000 for family coverage. So let's talk a little bit about, well, what happens if you let someone who is not eligible enroll? So let's say an employee enrolls a person who isn't eligible for coverage. That can have various consequences for you, but just what can you do about it? What can you as an employer do? First of all, you can do dependent audits, and that's where you can either do them yourself or you hire someone to request dependent information for all participants who have dependents. And oftentimes when you do that, you will find that there are ineligible dependents and they can be removed from the plan. So if somebody has an ineligible dependent, they should be removed prospectively generally, unless you can prove fraud or misrepresentation. Now, one of the ways you can do that is by including language in your open enrollment materials that if someone does add someone who is not eligible under the rules that you've laid out, then that's considered fraud or misrepresentation. And then you potentially can use a ACA provision, which is called rescission. So rescission allows you, if someone makes an intentional misrepresentation or fraud, for example, putting someone on the plan that isn't eligible, if you give them 30 days notice, then you can rescind coverage. And this applies whether it's a self-funded, i.e. the employer pays for the coverage, or fully insured, meaning that you have an insurance policy. And this can apply to both grandfathered and non-grandfathered health plans. So you do have the ability to go back and rescind coverage if you follow these rules, if there is an ineligible dependent that is allowed on the plan. So now let's talk a little bit about some legal disclaimers that you can put in your open enrollment materials. First, I would again remind employees that their benefits aren't vested, that the company remains, can terminate them or change them. Not that they will terminate or change them, but you may want to mention that. Also, that you definitely want to make sure that people understand that the benefits themselves are controlled by the plan's summary plan description, or SPD, and insurance policy and other plan documents. If it's a fully insured plan, it would be insurance policy, and then normally you have a wraparound SPD to cover the ERISA requirements. And also, one thing that usually is a good thing to mention is that when you enroll someone in benefits, that doesn't mean that that changes their employment status. That is, just because you say that someone can be enrolled in this medical plan for the next calendar year, that doesn't mean that you're going to keep them employed for that calendar year. So what are some other things that you can do to maximize the legal value of the document? So if all requirements are met, the open enrollment guide can actually be considered a summary of material modification, or SMM, for the underlying plan. Because SMMs, there isn't a prescribed format or model language. If you meet all the requirements, you don't need to send a separate SMM for changes discussed in open enrollment materials. So for example, if you were changing the deductible and the copay in your medical plan, if you meet the requirements for an SMM, you can make your open enrollment document be that SMM, and that keeps you from having to do another separate filing or separate document as an SMM. So what do you have to put on it? Well, first of all, it has to be legally accurate. You have to make sure it includes the proper information, and you have to include the name of the plan, and if you have that summary plan description, you just have to mention that. In addition, you have to identify what you're modifying or adding. And you want to say, of course, which you probably already have if you followed my other suggestions, that the plan sponsor has the ability to amend the plan. And then the effective date, if it's January 1, you just want to say that. And then you want to tell them that they should keep this SMM with their summary plan description, and that you have to read them together, and then you have to give them a contact name. So if you follow these requirements, then your open enrollment document can be considered to be an SMM, which will obviously shorten your, you won't have to send out a separate mailing. Additionally, you also have a disclosure that's called a summary of benefits of coverage, or FBC. And SBCs have to be provided to eligible employees at enrollment and upon request. So the SBC requirements applies to most group health plans, including self-insured and fully insured plans, as well as grandfathered plans. So if you want more information about SBCs, and then of course SPDs and SMMs, you can join me for the next short webinar that will be held on August 29th at the same time at 12:30. So I'm giving a little pitch for my next presentation. So let's talk about some other required notices. First, there's what's called the CHIP notice, which is the Children's Health Insurance Program. And you have to provide that annually to all employees. There is a model notice available at the DOL website. And actually, if you go to that website, it allows you to download it, so you can make any changes that you think you need to make, or you can put your name on it or other things. So that's a very good place to get that CHIP notice, because it includes all 50 states. And then there's the Newborns and Mothers Health Protection Notice that has to be provided at time and enrollment included in the SPD. So you can just include it with your annual materials. And that's basically the requirement that you can't discharge a mother after she's had birth based on certain specific timelines that you can't discharge her. And then the Women's Health and Cancer Rights Act notice also has to be provided. And this relates to benefits for after mastectomy and other treatments, and some required benefits. Also, as I mentioned briefly before, you have to, if you're a grandfather plan, you have to include your grandfather notice. And then patient protection notice. This is the notice that a person has the right to designate their physician, and that a person can choose their GYN, or a child, or a dependent, you can choose their pediatrician as their physician designated. Michelle's Law is still in place. It doesn't come up quite as often since the ACA changed the length of coverage for dependents. But if you have children over 26 and they're offered coverage in your medical plan based on student status, then you have to provide them notice, and you can't terminate coverage if they lose their full-time status due to a medical leave of absence. And then if they have any requirements for certification of student status, for example, if you make them provide a registrar statement or something else, you have to mention that. That's all part of Michelle's Law. Then you've got notice of HIPAA privacy rights. So you have to provide it at an enrollment, or you can do it in the open enrollment materials if they're self-funded. If it's a fully insured plan for a health insurance plan, then that's going to be provided by the insurance provider, for example, Blue Cross, Aetna, Cigna. They'll provide that notice directly. Now, one thing to remember is if you are self-insured, you may want to look at your HIPAA policies and procedures. The DOL has really started to do audits of HIPAA. And so this is a good time to go back and look at your policies and make sure that, excuse me, that everything is correct. Okay, Medicare also requires a notice of credible coverage, excuse me, or non-credible coverage. So if you have a medical plan and it covers prescription drugs, then an annual notice has to be provided annually before October 15th. Again, there are model notices and information. I've listed it here. And based on your timing, depending on when you do your open enrollment, you might be able to put your Medicare notice of credible coverage or non-credible coverage in with your open enrollment materials. So it's another option to avoid a separate mailing. But you have to be careful because it has to be before October 15th. Wellness. Okay, now as you know, lots of plans now, lots of companies are doing various wellness kinds of initiatives. And if the wellness is something that is related to your group health plan, for example, biometric screenings or giving non-smoker discounts or things like that, you have to include that in your, or should include it in your open enrollment materials. So if you offer incentives to employees that participate in activities or meet health standards, you have to offer alternative standards. If it's unreasonably difficult or medically inadvisable for someone to meet the standards. For example, if you give an incentive to someone joins a walking program and for someone doing walking is inadvisable, then you have to have an alternative. Related to that, you also have to provide them a notice of this alternative standard. So you need to be aware of that, and you should probably include it. You could include it in your open enrollment materials. And just as information, additional information is required if you are asked for medical information, such as the biometric screening. I will let you know that wellness is very controversial at the moment because the EEOC put out some guidelines, and they basically have been declared null and void as of 1/1/2019. And so we're waiting to see what the EEOC does in response. So I would say there's a big question mark over wellness and some of the wellness aspects, which I will cover either in my blog or tweeting or with another, with another flash notice or something if we get any official guidance about wellness. Okay, so change in status. As you know, change in status events are events that allow an employee to make changes in benefits, both, for example, in a health plan and also as in cafeteria plans. So they're kind of interrelated. So one of the things that it could be a helpful thing to include in your open enrollment is information about when an employee can otherwise make changes, like when they get married, when they have a child, when they go to part-time status, when a dependent reaches age 26, or when someone moves and their HMO no longer covers them. So I think that one of the things is if you include it here and you let them know what events employees have to provide notice, for example, the marriage and divorce, they have to provide you notice of those, is if you include them in your open enrollment, then if someone fails to notify you, for example, it often happens when someone gets divorced, they don't notify you that they are divorced so that you can give the ex-spouse coverage, and they just keep them on their existing plan. And if you put the notice in here, then that allows you to potentially use rescission to drop that spouse from coverage and to otherwise penalize the employee for not telling you about that change in a timely fashion. So it also is good to let employees know, just so they do let you know, for example, if they have a child or they're adopting a child, so that they can meet the parameters that you have set. So just some other thoughts. You know, you want to allow people enough time for the election process, but not too long. So you certainly don't want to allow them 2 months to make an election, but you might want to allow them more than 2 days. You know, you might want to make sure they have time to talk to their family about their coverages. And if you are going to be making major changes to your benefits that you offer, or for example, let's say that you currently have a HMO or a health maintenance organization, and you're going to go to a high deductible health plan, you might consider, you know, communicating some of those changes prior to official open enrollment, just so that people have a chance to understand it. And, you know, difficult concepts like flexible spending accounts health spending accounts, health reimbursement accounts if you have them, and how they work with high deductible health plan. You know, you want to try to make the language as clear as possible for them to understand those. And if you are using electronic enrollment, then you want to make sure that you include website links to their materials, like their summary plan descriptions. Go ahead and put those links in the materials so that they can go to those documents. And make sure, of course, that you meet the ERISA electronic communication rules if you are planning on using your enrollment guides as an SMM. So that's another important thought. So just some other considerations. Healthcare coverage is going to continue to change under the Trump administration. As you know, he recently approved the association health plans, which basically allows employers to band together for nothing more than being in the same area. For example, everyone that's in South Georgia, and employers can join together to put in plans that maybe don't have all the protections of the Affordable Care Act, but offers options that may be less expensive and that employees might enjoy having. Now, also to the Trump administration, there currently are several lawsuits underway with regards to whether or not the Affordable Care Act employer mandate should continue. And also what coverages, and do we even need to have exchanges? So you have to keep your eye out for those changes, and I will definitely be giving information if they do change. And also the mandate, because the mandate has been eliminated for 19, it'll be very interesting to see if employees then decide that they can drop coverage because they don't have to have coverage. And you need to make sure as an employer that you keep track of that, the fact that they've dropped coverage, so that you don't inadvertently end up with a penalty because you can't prove that you offered someone coverage. And of course, the midterm elections are coming up, and that could influence what happens with the Affordable Care Act, because, if the Democrats control, say, the House or the Senate, but then you have a Republican president, then you could have inaction potentially. Or, if it goes the other way and you have Republican control and let's say that it becomes a higher number, for example, in the Senate, then you could see more changes. So, it's just, you need to keep paying attention to what's happening with regards to the plans in healthcare. And then also, just as information, scrutiny of health and welfare plans, including their compliance with ERISA and ACA, that has increased, even though the Trump administration isn't necessarily in support of the ACA, many of their provisions of the ACA, they are still scrutinizing and doing audits. So that has picked up, it has not dropped off. So that's just something to keep in mind. And then now, if anyone has any questions, I haven't seen any questions pop up, but if there are any questions, please just go ahead and open them in the chat and I'll be happy to answer them. So I'll give you a minute to do that. Okay, well, it seems that no one has any questions. So seeing that, I think we will go ahead and end the seminar or webinar at this time. And just as information, here is my email, and you can follow my blog and also my Twitter account. And just as information, if someone in your office wanted to listen to this and they weren't able to, within a few days, it will be posted on our website and they can listen to it again or get a copy of the slides. Now with that, I am going to close this up, and I'm happy to see that a couple of people that I know have have indicated that they're listening and they're saying hello to me, so thank you. Hello to everyone that I know that has joined us today. And I really appreciate you joining us, and I hope that you'll consider joining me for the other 3 in this webinar series. And if you have any feedback about topics that you'd like to see covered or topics that you think you don't want to hear about, please let me know. I would really appreciate it hearing, because I'm doing this to provide you with information and to help make your jobs a little bit easier, because I know it's very difficult to comply with all of the requirements of the various legal requirements of ERISA, ACA, the Internal Revenue Code, and still make the materials something that individuals can understand. So again, thank you so much for joining us, and I hope you'll join me for my next one on SPDs, SBCs, and SMMs. Thank you and have a good day.